Well, hello there, ladies and gents. It is great to see you again, and welcome back to Closing Arguments. Ryan Ruff here, your moderator, but as always, I've got Jack Razumich standing by from the offices of Razumich and Associates, and we're going to be jumping into another criminal law-related discussion, as we typically do here on the podcast. I want to give a big thank you to all of our listeners and subscribers for tuning in to the kickoff episode for season 3 here of the show. Jack's been a busy guy. We dove into a year's worth of jury trials that he and his team have been, I don't even want to say knee deep, I want to say waist deep, maybe even shoulders deep in this past year. We talked through some of the lessons learned and really kind of the state of criminal law in today's day and age. A lot of good nuggets of wisdom, and frankly, if you find yourself in a courtroom in the near future, this is an episode that you might want to check out, just because there's a lot of lessons learned from Jack and his team over the course of the year and how the state really approaches a lot of cases. But transitioning into today's episode, as we sit down to record this, we're coming in on the exciting and fun Halloween holiday, as everybody enjoys each year. And we thought it'd be time to let's have some fun with this episode. So we've got a really unique conversation dialed up for you guys today. I'll set the scene in just a moment, but first, let's go ahead and say hi to the man of the hour. Jack, good to see you today. How you doing?
Hey, Ryan. Good to be back, as always.
Yeah, good to be back with you. We figured we'd have some fun with today's episode, given the time of year. Suing Satan and selling ghosts. What the law, when the law, that is, really meets this idea of the supernatural. We're going to be diving into some interesting things today. You and I were, we shared a few laughs as we were planning out the content for this. Criminal law, I'm sure, presents a lot of interesting things out there. This might have to take the cake in terms of what I'm familiar with. But where did you see this along the lines, the cases we're going to jump into today?
It's actually fascinating. We are going to talk about 2 cases today. They're both civil cases. So it's a little bit outside of our normal focus area. They say that truth is stranger than fiction, and I think that's sometimes true. Definitely, we get some interesting stories on our side. We've covered some of them in the past, but definitely you can't hold a candle sometimes to what the civil attorneys have to go through and the things that they hear and the things they're looking forward to. I think this is going to be fun. Anyone who knows me personally knows that Halloween is my favorite time of the year. Folks who have been to my office, I have 2 different photographs that I got from conventions of me being bodily threatened by different actors who played Jason Voorhees in full costume. I was also menaced by Robert Englund, the man behind Freddy Krueger. Given the amount of makeup that had to go into that, he was just menacing me with a knife glove, which is still pretty dang awesome in the grand scheme of things. But definitely, it's a time of year that I really love. When I was talking with some of my old law school buddies, these cases came back up when we were talking about ideas. And I'm really looking forward to sharing them with you because, as humorous as they are, believe it or not, they actually do teach us important things about the law moving forward.
Yeah. So as you sit there listening or watching us today, just know you will have something coming out of it. There's always something interesting. We want to make sure we give some sort of educational wisdom or nuggets to you guys at the end of the day. So, Jack, let's start with the fun one. They're both pretty fun, but I guess I'll just leave it to this opening question is, can you sue the devil? That's a loaded question, but give me some context into what I mean by this question and where this case really originated from.
The answer, shockingly, is maybe. So here's the scene. The first case that we're going to discuss today is a case called United States ex rel Gerald Mayo versus Satan and his staff. And the way that's designated, Gerald Mayo was attempting to file this by what's referred to as in forma pauperis, which means I'm too poor to actually pay for this. I want the court to pay the litigation expenses. The background for this case is in 1971, 22-year-old Gerald Mayo is serving a sentence in Western Penitentiary in Pennsylvania. Western Penitentiary at the time was a maximum security prison. So at the age of 22, he had already committed enough crimes and done enough things that merited a sentence in a maximum security facility. So rather than taking the time to think out and self-reflect on the idea that, okay, I have done something wrong, I needed to make changes, he hit on a phenomenon that is not unique to today. It clearly was a phenomenon 50-some years ago. This isn't my fault. It's clearly somebody else's fault. And in this particular situation, he decided that the person who was responsible for all of his misfortune in life was Satan himself, the Prince of Darkness.
Oh, man.
So he did, as one does, filed a lawsuit. And specifically, the actual decision itself isn't that long. I won't read the entire thing, even though it's only a few paragraphs, but I do want to hit the key points on it. It says that Mr. Mayo is alleging jurisdiction under 18 U.S. Code 241, 28 U.S. Code 1343, and 42 U.S.C. 1983. Those are the Civil Rights Acts. Those are the civil rights codes that came about in the 1960s that allow for you to sue people for deprivation of your civil rights. And more specifically, Mr. Mayo alleged that Satan has on numerous occasions caused the plaintiff misery and unwarranted threats against the will of the plaintiff, that Satan has placed deliberate obstacles in his path and caused the plaintiff's downfall. He alleges that by reason of these acts, Satan has deprived him of his constitutional rights as a United States citizen.
Wow.
Something that you need to understand about the American legal system, especially as far as the civil system is concerned, you can actually file litigation against anyone for just about any reason that you believe that you can create a cause of action for. There are systems in Europe, the English system, the French system especially, make it so that if party A sues party B and party B wins, party A has to pay party B's legal fees. America does not do that. We have it on the concept that everyone who is engaged in litigation is responsible for their own legal fees, absent a few very specific set of circumstances. The reason we do that is because it is assumed that if the losing party is responsible for paying the winning party's attorney fees, defendants who have deep pockets, like a large corporation, like let's just use Walmart as a great example. Walmart, not through any necessarily fault of its own, but Walmart is a very huge corporation here in the United States. It gets sued quite a bit for things like slip and falls, other damages, things of that nature. Walmart obviously has a lot of attorneys on staff. And if a person who wanted to sue Walmart lost to Walmart, which, to be perfectly honest, happens more often than we would care to admit. Even if Walmart did something particularly egregious, if that plaintiff is now responsible for paying the thousands of dollars per hour that Walmart's legal fees are going to cost, that creates a chilling effect where people will not sue large corporations or people with deep pockets,
Right.
Even if they do something particularly egregious that deserves it. So the U.S. system will allow you to sue for anything that you can basically say that a cause of action is attached to.
Right. So my mind's taking me to the next step here, Jack, is how deep are Satan's pockets?
That is a great question. He is potentially a foreign prince.
Right.
Where it gets interesting is the flip side of this is, of course, the courts have to deal with it.
Right.
People get this mistaken impression that if you just ignore a lawsuit, it can go away. That's really not true. It's especially not true for the people who are being sued. If you ignore a lawsuit when you're sued, bad things can happen to you. Of
course.
The court legally cannot just throw something out. A lot of the frivolous lawsuit things that you hear about and your people wondering about, like, oh, how did that get to this point? Well, it gets to this point because the court has to deal with it. And that's what happened here. And the decision actually is very, very well thought out. It talks about first whether or not the court even has jurisdiction over Satan, because that's the first issue. To sue in court, you have to establish some form of jurisdiction over the party that you're suing. So specifically, the court in this case said, we question whether plaintiff may obtain personal jurisdiction over the defendant in this judicial district. The complaint contains no allegation of residence in this district. While the official reports disclose no case where the defendant has appeared as a defendant in the account, there is an unofficial account of a trial in New Hampshire where this defendant filed an action of mortgage foreclosure as plaintiff. The defendant in that action was represented by the preeminent advocate of his day and raised the defense of the plaintiff as a foreign prince with no standing to sue in American court. this defense is overcome by overwhelming evidence to the contrary. Whether or not that would raise an estoppel in the present case, we are unable to determine at this time. So translating that from the slightly cheeky way that the court put it into normal terms, the law requires for litigation, the law requires that there be some sort of jurisdiction over the parties. There are two types of jurisdiction in American jurisprudence. There's what's referred to as personal jurisdiction, and there's subject matter jurisdiction. Subject matter jurisdiction would be something along the lines of if you and I enter into a contract to sell one of our houses. I'm here in Indiana. I can't remember where it is that you are, but the subject matter jurisdiction would be either of our two states. Because if I'm entering into the contract in Indiana to buy your house in your state,
right,
I have subjected myself to the jurisdiction of your state by merit of the fact that I'm in the contract with you. Same situation. Even if you never set foot here in Indiana for whatever it is that we're contracting to sell, by merit of the fact that you have entered into a contract with someone in Indiana, that can create subject matter jurisdiction over over whatever litigation is. The other type of jurisdiction is what's referred to as personal jurisdiction. Personal jurisdiction is a little bit more sensible. Personal jurisdiction means that the court personally can send the sheriff to go out and pick you up from your home and bring you before the court.
Yes, a little bit more forcible.
It means you're physically there. So every court in the state of Indiana has personal jurisdiction over me because I am in Indiana. A court in Wyoming. I've never been to Wyoming. It's one of the few states that I've not been to. Wyoming does not have personal jurisdiction over me. That doesn't mean that it may not have subject matter jurisdiction over me if I have some sort of legal dealing with Wyoming, but there's no personal jurisdiction. So the first problem that this lawsuit created is whether or not jurisdiction existed. There was no allegation that Satan actually lived in the Western District of Pennsylvania. I have friends who live in the Western District of Pennsylvania, and I'm sure that they have opinions on that.
Sure.
But as far as the court was concerned, there was no allegation that Satan had that the court had personal jurisdiction over Satan in the Western District of Pennsylvania. The unofficial account that the court was referring to is a 19th century short story called The Devil and Daniel Webster. Great story. I do highly recommend anyone who's just looking for something fun and quick to read during the month of October, look it up. They also made a really good movie about it. The argument in that case that they're referring to is, really quickly, just the very brief focus on that before you get too sidetracked. Satan enters into a contract. A guy sells his soul for riches and big property, reneges on the deal. Satan files a lawsuit. That's probably one of the genesis where all lawyers go to hell come from. Satan files a lawsuit in New Hampshire alleging specific performance. He wants that guy's soul. Guy hires Daniel Webster, who is a real person. Daniel Webster is not a fictional person. Daniel Webster was a real person who I think was still alive when the story was written, to defend him. And Daniel Webster's first argument is that as a foreign prince, the devil does not have jurisdiction to sue in American courts. That goes back to I want to say it's the 11th. It's either the 11th or the 12th Amendment. It discusses who has standing to sue in American courts. And one thing that is typically not there is if you are a foreign citizen, you can't sue in an American court. That is a jurisdictional issue.
Makes sense.
Now, in that particular case, Satan alleged that he was an American citizen. He actually can only be citizen of all nations, and the court accepted that argument. So the concept is, does that unofficial account prevent Satan at some future point in time from arguing that he is not subject to the jurisdiction of American courts? We'll talk about it. Yeah, it's like we'll talk about estoppel in the next case. Like, it's a legal concept to come up in both of these cases.
Yeah.
But the argument is like, well, maybe he's subject. Maybe there's subject matter jurisdiction. Maybe there's personal jurisdiction, but there's no allegation on that.
Sure.
The final thing that really prevented this lawsuit from ending that resulted in this lawsuit being dismissed, the issue of service of process. When you file a lawsuit, if you are the plaintiff, one of the things that you are required to do by the rules of procedure is you need to direct the court on how to notify the other party of the lawsuit. You can't just file a lawsuit in secret. There has to be notification so that the person who is being sued has the ability to respond and answer to it. So in this case, the final thing that the court noted when it was making its decision, it says, "We note that the plaintiff has failed to include with his complaint the required form of instruction for the United States Marshal for directions of service to process." They couldn't serve Satan. So even if there was subject matter jurisdiction, even if there was personal jurisdiction, if you can't serve Satan with notice of the lawsuit, you can't sue Satan. So it's a hyper-technical situation.
Sure,
It doesn't say that you can't sue Satan. It just says that you need to establish that there's jurisdiction over Satan, that Satan has the ability to be sued in an American court, and more importantly, that you can actually serve Satan with notice of the lawsuit. Those are the things that are required to be able to sue Satan in court.
Yeah.
So to answer your original question,
checked also, Jack, I don't know where you can find them, where you go deliver those papers. I think back to all the movies and funny skits of, you've been served, and somebody just handing Satan there a piece of paper saying you got to show up in court because Gerald Mayo says so. That's great.
It's that would be the bravest process server ever at that point in time.
So true. That's great.
But yeah, this case actually it's kind of a famous one in law school, sir. It actually is taught in law school because of those issues that we talked about.
Oh yeah. There's some fundamental lessons to be learned from it, and it's quirky, but I love that the case was given its due course and its time, that it should have been allowed, because in today's day and age, especially like you said in the civil court system, anybody can file paperwork for just about anything. So it helps to have maybe some foundational ground now to stand on as I'm sure another instance of this, as slightly adjacent, has probably popped up, in years to come. But I gotta, whatever happened to Gerald Mayo? What was in his future? That
is a great question. The way the court system works in the United States, especially on the federal level, obviously all Supreme Court of the United States decisions are recorded. There are 3 different recording systems that basically give you all the Supreme Court decisions. All Court of Appeals for the currently 13? There's 12. Yes, 13. I don't practice federal law. That's our disclaimer right now. Do not hire us for federal cases. We don't practice federal law. There are 13 circuits total that represent the appellate courts in the United States. They are required to have all their decisions recorded as well because they have multi-state jurisdictional issues. Cases like this, district court decisions are available, but they're not always recorded the same way. Typically, only cases that have some degree of notoriety or some degree of important legal precedent, or I think really in this case, some degree of the publisher just thought this is an awesome one, let's talk about this. One of the disappointing things of this case, in my opinion, is we don't actually know what Gerald Mayo's complaint said in its entirety. 1971, this is obviously well before any type of electronic filing. This would have been a paper filing since he was a prisoner in a maximum security facility. It almost certainly would have been written by hand. There probably wouldn't have been access to a typewriter. Computers in 1971 were highly expensive and probably not being put in the prison rec room.
No, can't imagine.
And so the complaint itself has just disappeared, which is a shame. As far as Gerald Mayo as a whole, we looked like we spent a good week when we were getting this case prepped, and I can't tell you, certainly not easily. I'm sure that if you put a serious dedicated effort into background checks or really running this down, you can find it. But I can't really tell you what he was in prison for in the first place. I can't tell you when he was released. I can't tell you if Satan eventually stopped putting roadblocks in his path and he started walking the right of the righteous man. All I know is that the district court gave this case actually a great deal of thoughtful and respectful legal analysis, and he never filed an appeal for it, because if there was an appeal, there definitely would have been a record of that one.
Sure.
But he just kind of let it go. But
he couldn't serve Satan. He was looking and he just couldn't find him. So if you can't process, you can't appeal. So A lot of movies typically end with a happy ending, Jack. I don't know if Gerald Mayo in this case, especially with Halloween-related movies, are going to end in a satisfactory or happy, shall I say, ending for Mr. Mayo. But that's such an interesting court case, and it's great for this time of year. And Jack, there was another one that we wanted to dive into today, and I'm sure as people are sitting down listening to today's episode, they might even be on their way to one of these now, and that's a haunted house. I was just catching up with some friends this past weekend, and their family was making some plans to go visit a haunted house, and a lot of these haunted houses these days will have these rules where you can wear a vest, and it's either a color green or a color red, and when you're running through, if you're wearing the color green, that means the people inside that are scaring you can jump out and touch you. They can grab you, they can influence your movement and your direction, and some people don't like that, so they wear the red jersey or penny or whatever they ask you to wear, which is terrifying to me. I think I would absolutely choose the red one if I'm running through a haunted house. But the next case we wanted to jump in today is surrounding this idea of haunted house. There is only a legally haunted house in America. There's one. Let's talk about this haunted house, how that came to be, and the case surrounding this.
Sure. So there is exactly one legally haunted house in the United States of America. And by legally haunted, I mean a court decision has legitimately said, as a matter of law, this house is haunted. Mm. It still stands. We'll talk about what the situation of the house is here towards the end. But again, it's a fascinating case that, again, goes back to the issue of execution of contracts and how these laws are supposed to be interpreted. So the case at issue is a case called Stambovsky versus Ackley. And I apologize, Mr. Stambovsky. I grew up with the name Razumich. I can pronounce it because I've always had it, but the number of people that I run into, I feel your pain, Mr. Stambovsky. And I apologize if I'm mispronouncing it. So what happens is in Nyack, New York, which is upstate from New York City, a woman by the name of Helen Ackley has been living in a house that she has reported the existence of poltergeists and hauntings in her house on at least 3 separate occasions to national publications as well as the local newspaper. She was written up in Reader's Digest. She was written up in the local paper. And her house was on a 5-house ghost walk tour for being haunted. So this was a house that very much she was establishing as, this is a haunted house. This is my haunted house.
Yeah, and let me pause for a hot second there. To get written up in Reader's Digest, as well as just basically receive a little bit of reputable gusto, if you will, behind your claims, means people went and felt what she was feeling. And as somebody I get wigged out going to these kinds of things and pretty scared pretty easily. I'm feeling for this woman. I'm feeling for her. Not fun, but sorry, continue.
Sure. So, like all people, eventually Helen reaches retirement age. She wants to sell her house and move elsewhere. So she hires a realty company. The company is, where is it in my notes? Ellis Realty. She hires Ellis Realty to help her sell the house. And Ellis Realty gets in contact with an individual by the name of Jeffrey Stambovsky. And they agree. Jeffrey is from New York City, so he's from about an hour south of where Nyack is. They enter into a contract, and the agreed upon price is they are going to buy this house. Helen's going to sell this house to Jeffrey for $650,000. That's what the agreed sale price was for the house. Jeffrey puts down a down payment of $32,500 to secure the purchase of the house. When it comes time to have Helen sign her half of the sale contract, so he has signed his intention as buyer, Helen still has to sell the seller. Helen talks to Ellis Realty and says that I'm not going to sign until you disclose the existence of the haunting, because she didn't want to sell the house. Allegedly, she did not want to sell the house that was haunted to someone who didn't know what they were getting into.
Good on her. That's great. I mean, talk about some moral obligation there. That's great.
Here's where it gets fuzzy, though.
Okay.
Helen I have no reason to doubt that Helen said that she did not want to sell the house without having the disclosure. Given how much she had talked about the haunting, it's definitely something she very much believed. Where there's question is the realtors. Ellis Realty claims that they talked to Jeffrey Stambovsky, disclosed the haunting. Supposedly, Stambovsky laughs it off, says we'll have to call Ghostbusters in at some point in time if it becomes a problem, and just basically shrugs it off.
Yeah,
this information gets back to Helen. Helen signs her portion of the sales contract. Stambovsky denies ever having been told this. About a week later, after all the paperwork has been signed, the purchase agreement, the sales agreement, after all that's signed, about a week later, Jeffrey Stambovsky asks to meet Helen in person and look at the property and discuss this concept of haunting. So at some point in time, he is aware that there is a haunting. The record is a little bit flexible as to exactly when he finds out.
Sure.
Whether he's
not
actually
to mention, there's public record, right?
Yeah.
From the Reader's Digest article and just general knowledge of the property. So there's that too.
There is that, but again, we're looking at this from the perspective of we're filming this in 2025. This is 1990.
Very fair.
The internet was basically dot matrix message boards. I was there when dinosaurs roamed the world. I saw what the internet was.
Sure. It wasn't much in 90.
So the ability to find these things back in the day is a problem. That forms kind of the crux of what the lawsuit is. Because Jeffrey Stambovsky sits down and he spends a couple hours with Helen Ackley, who passionately goes on about the hauntings and everything that's happened in the house and the history of it and all the weird things that have happened. And she very clearly believes this. Like there is no, this isn't putting on a show. This isn't doing anything along the lines of basically trying to downplay something. She legitimately believes this. She is legitimately relaying this information. And Stambovsky says, nope, not for me. And he files a lawsuit in the New York trial court. New York does their court system a little bit weird. The trial courts in New York are referred to as the New York Supreme Court. The Court of Appeals is the New York Supreme Court Appellate Division, and the actual top Supreme Court in New York is the New York Supreme Court of Appeals, if I recall correctly. But I'll just try to use this in the terms that we understand: trial court, Court of Appeals. So Stambovsky files in the trial court an action for rescission of contract and seeking damages for fraudulent misrepresentation. His argument is, if I had known this house was haunted, I would not have bought it. So I want my $32,500 back, and I want damages on top of that for wasting my time in making me go through all this for a house that clearly is not suitable for purchase. Stambovsky himself did skip the closing date. The $32,500 down payment did not obligate him to buy the house, but by not showing up the closing date, he forfeited that by operational law at the time, and that's what led to the lawsuits. He wanted his money back, and he wanted money on top of it for wasting his time. So the trial court dismisses it outright. At the time, New York State had a very, very strict caveat emptor or buyer beware policy on real estate purchases. If you've ever seen something where it says the property is in as-is condition, that's basically what buyer beware caveat emptor means. And that was the law for property transactions in New York in the early 1990s. So the trial court basically said, this is your responsibility. There is no duty to disclose.
Yeah, best of luck, pal.
Sucks to be you, I guess. Enjoy your haunted house or enjoy not having $32,500.
Yep.
Stambovsky appeals it up to the Court of Appeals. And here's where things get interesting. And this is the legal precedent that this case controls. At the beginning of the decision, the Court of Appeals holds that having reported the ghost presence in both national publications and local press, the defendant is stopped to deny their existence, and as a matter of law, this house is haunted. So What that means, and this brings back the concept of estoppel that we talked about a few moments ago when there was an issue.
I was just going to ask you to clear that up for anybody who's unfamiliar.
So estoppel is a legal concept that says the easiest way of describing is the no takebacks concept. If you hold yourself out or you hold something out as being X, you cannot then say it's Y if it's inconvenient for you. So in this particular set of circumstances with regards to the haunted house, because Helen Ackley had spent so much time claiming that the house is haunted, she is legally prevented from taking that back and then telling people, I just made it all up. You see the same thing kind of with the Amityville house. Now, the Amityville house has been the subject of different litigation over the years. But if the owners of the Amityville house ever tried to say, yeah, look, it's not haunted, it was all fiction, it was all made up, they probably would have a hard time doing that. Mm-hmm. You can't, in law, spend a lot of time saying that something is one thing only to later say that it's not. Looping it back to Gerald Mayo and Satan, the estoppel in that case is if Satan had actually appeared in an American court and said, I have the ability to sue in this court because I am an American citizen, he could not at a later point in time say, you can't sue me, I'm a foreign prince, you have no jurisdiction over me. Mm-hmm. You don't get to say that you are one thing when it benefits you, and then if it's going to come back to harm you, say at a later point in time, I was just kidding about that.
Hence, no takebacks.
No takebacks. So by law, this house is haunted. Whether or not it's actually haunted is a debatable issue, depending on whether or not you believe in ghosts or how your opinion of that goes. But by law, it is haunted. Every time this house sells, it is listed as a haunted house. They can't not disclose that, especially since changes in New York law over the last 30-some years have made more disclosures mandatory. So, for example, this is one of those things that you see everywhere. If someone has died in the house, that has to be disclosed.
Right.
That's kind of, again, a byproduct of this because people don't like living in houses where people have died. Mm-hmm. It might be haunted. This house we know is haunted as a matter of law.
So what's there's a lot of people listening to this, watching this episode that are like you, love the Halloween holiday, are super excited about this. What's going on with the house now? Where does it exist? Is it still for sale? Can somebody buy this? Is it a registered landmark? What's the deal with the house?
The house is still in New York. Unlike with Mr. Mayo, Mr. Stambovsky got something of a happy ending with this case. The court found that the fraudulent misrepresentation, that was properly dismissed. The caveat emptor was so strong that the fact that there was no legal duty to disclose the haunting separately, if Stambovsky was not made aware of that, as he claims, that did not represent fraudulent misrepresentation because there was no requirement to. The court did, however, argue that the rescission should be granted. And with regards to that, what the court found was that the haunting was not a condition that a buyer or potential buyer of real property can and should be able to ascertain upon reasonable inspection of the property. So the idea being, yes, it's buyer beware, but that's got limits. You know, if you go to a house, you can look at a house and you can see whether there's mold. You can see whether there are termite marks. You can see whether there are rat droppings everywhere. That would make that caveat emptor thing something that can be done. Because the idea is, even at that time in the 90s, you could still, there's nothing that prevented you from going to inspect a property that you were looking for. But ghosts aren't always active. At least the people that I know, and I have known people over the years. I spent a disturbing amount of time in college in cemeteries with a ghost hunting group because I was
that's fun.
Seeing someone in that, but that's a story for a different day. Ghosts aren't always active, according to the people who hunt ghosts, who look at ghosts. So if you show up to inspect a house that the owner knows is haunted and the ghosts just aren't busy that day, mm-hmm. you're not going to find out about the ghost. You know, unless you're there and the books are moving or the piano's playing or what have you, you may not be able to find out about that. So what the court found is that because, according to the doctor in a caveat emptor would normally operate to bar a rescission action, causing the seller to have a duty to affirmatively disclose information about the property to be sold. The doctrine and emerge law and equity system can be modified to do justice to the parties. In this case, the most meticulous inspection and search would not reveal the presence of poltergeists of the premises or unearth the property's ghoulish reputation in the community. So equity allowed for the rescission of the contract. So Stambovsky was refunded his $32,500.
Wow.
So he got a happy ending in the concept that he didn't have to buy a haunted house, and he wasn't out $30,000.
Mm-hmm.
It also ended happy for Helen because this got a lot of attention. This got more attention than Gerald Mayo's case does. We're in the 24-hour news cycle at this point in time. Entertainment Tonight exists. All sorts of places trying to fill their 24-hour news stations with interesting slice of life stories. And of course, this is happening in New York. This is happening in what it was at the time, the media capital of the planet.
Mm-hmm.
Even though Jeffrey Stambovsky backed out of the deal successfully, Helen got flooded with offers to buy the house.
Sure, I'm sure.
And she had no problem selling it with the reputation of being haunted, which she did in 1991. She retired to Florida, which is what her plan was, where she lived out her days until she passed away peacefully, as far as we know, in 2003. Whether her ghost went back to the house in Nyack is a good question. Her son certainly thinks that she did.
Okay.
But that may or may not be correct. The house itself has been sold several times since then. The most recent time that it was sold was in 2021. So about 4 years ago, it was sold for just about $1.8 million.
Wow.
It does still enjoy a lot of notoriety locally. I don't know if it's on the National Register of Historic Places or not, but it certainly is in the Register of Legal Precedents. It is the only legally haunted house in America, and that is, again, something that is really cool. This is another case that gets taught in law school because, again, talks about the concepts of what your contractual obligations are in real estate and the requirement to disclose and when you can rescind a contract. It's a case of contract law about whether or not there is an equal bargaining power if both sides are armed with the correct information to be able to come to a mutually agreed upon consideration for the execution of the contract. So yeah, it's like, again,
fascinating.
Yeah, it is. That's all there is to it. Like it is a legal precedent. It does have things to teach us, and it has the outcome of being awesomely the only legally haunted house in the United States.
And it gives us great content to sit here and talk about on the show.
Which is probably the best part about all of it.
Exactly. Well said, Jack. No, Jack, two very different, but also very fun court cases. It's not typically the type of thing we cover here on Closing Arguments, but given how much fun this holiday is and how much I know you enjoy it, we wanted to make sure we had fun today, sit here and talk about some interesting court cases. Folks, we'll be right back on our regularly scheduled programming, if you will, as we roll into the month of November here coming up. But yeah, a lot of fun today. Jack, is there any you mentioned these are taught in law school, which I love. I think that's great because they're quirky by nature, and some of the best cases are quirky by nature because there's specific information or evidence that comes to play in the 11th hour of a given trial, and that's what helps set precedents moving forward. Any final thoughts of your own?
I have had defendants tell me that the devil made them do it. I've not had them ask me to sue in court for them. I will tell you that even if the devil made you do it, maybe talk to your attorney about a slightly better defense that's going to be acceptable to the court. As always, if you think that I guess Satan making you do it would be a concept of duress. That's an affirmative defense that we talked about a season or two ago. So if you think you have a viable defense because Satan made you do it, or that the poltergeist in your house are responsible for the property damage or the battery to one of your house guests, give our office a call. We'll listen to you. We'll treat it seriously. We will look into whether or not there is a viable argument that a third party like Satan or a poltergeist was responsible for the criminal action that you have been charged with. And if nothing else, it's definitely something that you want to contact an attorney about. If you are involved in the legal system, whether that involvement is a result of supernatural forces or the more mundane forces of law and order. Give our office a call at 317-983-5333, and we'll be happy to discuss your options with you and determine whether or not we can successfully blame it on Satan or poltergeist.
Or the devil. There you go. I love it. Jack, thanks so much for carving time out of your busy schedule. I know you got clients to serve. We'll let you get back to doing that. But there you have it, folks. When the law meets the supernatural, we'll be back again next episode, diving into some, more granular or, as Jack just put, mundane cases. No, we always like to bring you guys fun stuff here on the show. But Jack, appreciate you and your time. We'll see you back here on the next one. And folks, for you out there listening or watching, we want to take a special moment. Always thank you guys for making us a part of your day. If you enjoyed today's discussion, it was a fun one. Make sure you hit that subscribe button on whichever platform you check this out on today so that you don't miss out on any future conversations where Jack and I dive into these criminal law related topics so that you and yours can come out better for it on the other side. And dare I say, have some fun along the way. But look, for Jack, I'm Ryan. We're going to go and say so long now, but we appreciate each and every one of you stopping by and being with us today on Closing Arguments.